this session. Since this is a public meeting, I will open the public meeting and ask the Conservation Commissioners, including those of you hiding in the back, to come up here so you can be introduced. My name is Bill Hecht. I'm Chairman of the Commission.
Jamie Mullen.
Brian Tucker, who's a former member.
Hi, Anita Scanlon, member, current member.
Brian Sullivan.
Okay, what?
Barbara.
Yep, and Barbara Stewart, the keeper of all good things.
And a couple other people, Chuck, our administrator.
Right, and Kim, who has been, is the secretary for, recording secretary for the commission.
And there are two other people I'd like to introduce. Pat Lloyd and Will Finch, who were on an ad hoc committee last summer to help us formulate these changes to the regulations.
Let me try and cover quickly what we're going to do tonight. First of all, you each should have received a large strikeout version of the actual real changes. Part of the real issue we have is when we presented these changes to the selectmen, there was some confusion. So they asked us to go back and try and come up with a variety of ways of explaining the changes. So we've done that as a commission. But I want to make one point, and I will probably come back and make that point a number of times. This is the only official version, okay? So that if you have questions or you don't understand our explanations, go back to the official version and we'll try and explain it to you. Our idea tonight is to really have a two-part program. Given that we don't have a huge crowd here, our plan would be for each commissioner to take a couple of two or three of you and walk through the various ways of describing what's what. And let me say that we have three versions. One tries to, which Jamie authored, tries to explain the rationale for the changes. A second version that Barbara drafted.
And that version is on the poster on, I guess that's the west wall over there leaning against the window.
And the second version is a version that tracks, looks at the changes and the old regulations. And the third version simply tries to put the regulation changes in 5 specific categories. There's nothing magic about 5 categories, but as we looked at the regulation changes, our guess estimate was there were sort of 5 ways to group them. People could have grouped them in 6 or 3, but I chose 5. I want to introduce Jamie Mullen as Vice Chairman, and I don't know, you have some more to say?
Well, just to reiterate what Bill has said, we can take you around and explain these changes to you in small groups, or we'll be stationed at the 3 poster stations with the 3 different explanations that Bill talked about, and you can come by if you're not with a group, and one of the commissioners will tell you what the proposed changes to the wetland regulations are. And just one quick word of background, this is a process that we have been working on for 18 months. It was done at the initial request of the Board of Selectmen because the Board of Selectmen had feedback from their constituents that the regulations were confusing, they were a little bit convoluted, so they asked us to look at simplifying them and see how we could make the process of applying for and obtaining a wetland permit simpler without compromising the critical wetland and natural resource protection offered by the regulations. Last fall, we made some changes to the bylaws, and since then, we've been working on the changes to the regulations, which are the cookbook of what you have to do, whereas the bylaws give the overview. So, with these, after this public meeting, the Conservation Commission, who is charged with drafting and approving regulations, will vote on these changes to be modified by feedback we've received here this evening as appropriate, and we hope to actually vote and make those changes at our regularly scheduled Conservation Commission meeting a week from tomorrow.
The other thing that I want to remind you of is we've given you all a comment sheet. We will have a second part of the session which will open it to questions from the floor. But there are two things. One of them is if you choose not to ask a question at the public end of the comment, we won't have a record of it. So please, if you choose not to ask a question in public, write it down so we can make it part of the public record. One of the things we're going to do is each of the presentations you see will become part of the record of this meeting as well as the minutes of the meeting.
And they were comment sheets. I think
Yeah,
they
there
were
are
handed
comment sheets, and I think each of you either got some or got handed some. And those comment sheets, as I say, are one of the two methods for us determining the feedback. Are there any questions at the outset? If not, the commissioners are going to disposit themselves on those things, and those commissioners who aren't responsible for one of them will lead you around. Oh, come ahead. Join us.
So sorry we didn't. I kept cutting the question.
Once again, let me remind you that there are two ways to get on the public record. One of them is to ask a question. The other one is to fill out a comments form. If you fill out a comments form and you don't want to ask a question, those comments forms will be collected. They'll be part of the public record. If you wish to ask a question, that's what the second half of this meeting is for. Again, let me reintroduce Anika. Why don't you start?
Anika Scanlon.
Brian Chucker.
Brian's a former member of the commission. Bill Heck, chairman.
Jamie Lawn.
Brian Sullivan.
And Barbara Stewart in the back who will join us. Each of us are commissioners. Let me open it for questions.
Questions, comments, input that we should consider as we vote on this change?
Mr. Heck, I sent a letter on behalf of a dozen or so neighbors about a year ago to the commission, which has 10 questions.
Right.
So I won't bore you with all of those questions tonight. But
You will get a written response to all those questions now that we have written the regulations. Since
Perfect.
it turns out that writing the regulations, even though I like to respond to mail, you as neighbors had a letter. We'll respond to those in writing.
I figured that would be the case. So I've put them on the public record. I won't go through
Fine.
those.
No problem.
Thank you. I appreciate that. And I appreciate the work that all of the commission has done. In one of your meetings, there was a comment made that you really had a hard time, you and Mr. Maugham had said you had a hard time unweaving the regulations from the state regulations.
Mm-hmm.
So I'm wondering if you can address how you were able to arrive at the list of suggested regulations if in fact you had a hard time unweaving them from the state regulations.
Well, I'll take a shot at that. The process was that during the summer, late spring and summer of 2011, we formed an ad hoc committee, which consisted of 2 or 3 current conservation commissioners and other people with expertise in wetland science and engineering. And what we did through the course of the summer, we met almost every week, and we invited people to make comments. We invited, come in and testify, if you will, or talk to the ad hoc committee about their concerns with the current regulations. We talked to several attorneys, some developers, wetland scientists, some environmental advocacy groups that we talked to, and we talked to a number of applicants. In addition, we posted on the TAN webpage and sent out to a lot of TAN leaders surveys to ask those same questions. We got over 1,000 responses to that survey. We went through all those interviews, we went through all those survey questions, as well as our own review of the regulations and our own experience, and we identified about 20 plus or minus areas that were a problem to one of the stakeholders, one of the applicants, one of the wetland scientists, one of the engineers. And what that ad hoc committee then did was write a report to the Board of Selectmen about those 20 or so areas. Some we were able to deal with at that time, but most we put off to be dealt with on a case-by-case basis by the Conservation Commission, which is what we've been doing for the last 14 or 16 months. So we had those areas that were problems, if you will, and we dealt with those one by one and came up with the 14 or 15 changes.
So you have successfully then been able to go back in and look at and compare the state laws and the local laws?
That was part of the process.
Okay, all right.
One of the challenges, and I probably, since I said it, I'll explain it. One of the challenges is that state regulations are some 300 pages long.
Yep.
And mention things in a variety of inconsistent ways, sometimes contradictory ways, often just simply part of an explanation on page 37, part of an explanation on page 58, part of an explanation in the addendum on page 437. And the difficulty of doing that really without the work of the Summer Commission would have been just about impossible, because in fact, if you look at the comparison between our changes and the state changes, wherever possible, we have basically adopted the state regulations. There are a number of areas where we have not adopted the state regulations. We have maintained the Reading regulations in a number of situations.
So, thank you. That helps me understand what the process was. So one of those areas was isolated wetlands, which the state does not address at all.
Right.
That's correct.
And I noticed that the recommendation is to allow up to, I believe it's up to 500 square feet of isolated wetlands. So my question is, why not 5? Why not 5,000?
That is a very good question. And we have had a lot of discussion with that. And the ad hoc committee over the summer tried to come up with a number, and we couldn't. We said, let's open it up, and then the Conservation Commission said, let's throw a number out there to start with, and if we get feedback and we learn of scientific studies or we learn of other towns that have come up with a better number, we will be more than happy to consider.
So what is the issue about Reading protecting them and the state not protecting them?
Reading, as you look around, is a town that has a lot of wetlands now, but 200, 300 years ago had a whole lot more wetlands. We've probably lost, I don't know the exact number, but it's easily 40, 60% of our wetlands have been filled for development. As part of that filling process, what has happened is very large wetlands. Take, for example, the Birch Meadow where all the athletics fields are. That at one time was a large wetland. It's been filled, and the process of filling those wetlands has isolated some of what were formerly contiguous wetlands. So we have an abundance of these areas that have been isolated by historic fill. So that's one reason that we've decided to protect them. The second reason is that, as I said, much of the newer, by newer I mean since 1950 homes in Reading are built in fill areas. And that fill has left some isolated areas. Those isolated areas in residential neighborhoods are very important for flood storage. If we allow indiscriminate filling of those pockets that are left, that flood water has to go somewhere. And those isolated pockets, by and large, are surrounded by schools, residential homes, and businesses.
So the town is
and that
using,
flood water would go into those homes and
so
businesses.
the town is using that private property as a way to mitigate.
In some cases, it's private property. In some cases, it's public
Oh,
property.
beyond shadow of a doubt, but in this case, I'm specifically addressing the use of private property for a general benefit to the town,
It's the
not to have to address the drainage issue.
It's a general benefit to the town, but if that isolated wetland is on your property or any individual's property, it's storing the flood water that's coming off of your roof.
It would go in their basement.
It would go in your basement.
One of the best examples of this is if
Or your neighbor's
if you look at the Parker Middle School. The back soccer field in the Parker Middle School is essentially a filled wetland. If you know anybody who is downstream from the Parker Middle School, you will know someone who has a wet basement. And I'm not talking about a damp basement. I'm talking about
Water flowing through.
water flowing through your basement. The reason for that is after 100 years of straightening rivers and building dikes and building dams and building flood storage, even the mighty Corps of Engineers has come to the conclusion that wetlands are in fact the world's best storage mechanisms for floods. What ends up happening is if there is flood storage, a wetland is like a gigantic sponge. It absorbs the water and it very, very slowly, think of a sponge in your kitchen. If you get one drenched and you let it dry and you don't squeeze it, it will very slowly dry out. And that's precisely what happens. If you do any of the other things, you end up with the water increasing in flow, in volume, in high peak rain runoff, and essentially flooding other people's basements.
So it's controlling the rain post-storm. It's not flood in the sense of the biblical flood and floodplain. It's controlling that flow.
It's both.
So, well, there's a floodplain map which determines what happens with flooding, and then there's the wetlands.
If you look at most of the wetlands,
they're in that floodplain.
they're in that flood.
Right. In the residential property or the private property that has those isolated wetlands, that's really a drainage issue. So
no, it's not a drainage issue.
Well, it's a drainage issue in this sense. If I was a property owner who wanted to actually mitigate that water on my property, I have mechanisms to do that.
And what is that mechanism?
To actually connect to nearby drainage.
You can't do that under the stormwater regs. You cannot pump that drainage into
It's not drainage. I'm not saying pump anything.
or even let it flow.
Even let it flow. It's illegal to take water from your property and put it into a drainage.
So over the history of Reading, those people have built up their properties and have flooded mine or flooded a neighbor's and created a wetland, which is now depriving us of some of the use of the rights of that property. Pretty much we're up a creek. But if we had the state laws, it would be a very different situation.
If you had the state laws, it might be a very different situation. The real issue then is the question of where does your floodwater go into your neighbor's basement?
Right, that's a very specific question.
And the fundamental question that we have, it's the reason this state is called a commonwealth, is there is a commonwealth. We have certain things we hold in common. Some of them are in fact in private property.
Yeah, oh, no doubt. I'm not here to debate the politics of the Commonwealth. I'm questioning whether or not there's a tangible reason why the commission would not want to, for environmental reasons, address each of those individual issues as they came up, should a property owner want to mitigate that situation.
As we heard feedback from people, having a set of regulations and a local bylaw which protects the town in the way the town has historically been protected is probably the most sensible scientific.
So the answer is because we've done it that way, we will continue to do it that way.
Because flooding still exists.
Yes.
Yep. Yeah, David, one other thing I'm Will Finch, former commissioner, and I was on the ad hoc committee. One thing, I think, one reason that Reading doesn't have the catastrophic flooding issues that many other towns do is because we've been preserving these isolated wetlands since 1976. So there's a lot of them around town that contribute to the overall flood storage in town, and we really don't want to start whittling away from that. But we don't get the catastrophic flooding even on the Ipswich River that many other towns do, and I think it's in large part due to the fact that we have preserved a lot of these smaller.
One of the interesting issues too is that
it's a choice.
And it is a.
It's a choice. I mean, we're making a choice, right? So the question is,
and both the ad hoc committee and the full conservation commission discussed this issue. It wasn't as if the issue didn't come up.
Oh, you shut it down. No, you guys have been working very, very hard.
So we did consider it and reached consensus on the proposed change to the regulation. But we certainly welcome input as to should that area be larger or smaller, and if there's any fact, any documentation, any historic representation to indicate a different size, we'd be more than happy to consider.
One last question on that, and then I'll shut up. Which is very hard for me to do, for those of you who know me. The fact of the 500 feet. If there was an existing space that is currently designated as an isolated wetland, how do you determine, does that then allow the property owner to exempt 500 feet? I know we've talked to individuals in a business who have said, look, I don't even have 500 feet that's being denied the use of. So how does that how do you adjudicate the 500 feet?
There's not a 500-foot exemption. The way the regulations are drafted is that if that isolated wetland in total, no matter whose property it's on, it could be on 10 different people's property.
Yeah.
If it's 500 square feet or more, then it is a jurisdictional wetland, and the wetland regulations apply. If it's 499 square feet, it's
Yeah.
not a jurisdictional wetland, and none of the wetland regulations apply.
Got it. Okay, thank you.
Any other questions? Yes.
I just had a comment.
Could you
about-
introduce yourself, just so we got
Carolyn
you?
Whiting.
Yep.
I'm writing from Birch Meadow area. I had a comment about the change so that you have to have 2 out of the 3 factors. And it seems to me that it might make sense to say, okay, if you only have this hydric soil that's left over from when it used to be a wetland, and you don't have either of the other 2, then fine, it's not a wetland. But if it has one of the other 2, maybe that should be, or I think that should be sufficient.
One of the interesting challenges is that the original regulation in the town basically said any one of 3 situations, either water, hydric soils, or wetland plants. When we examined that, one of the chronic issues that comes up is a lot of people have wet backyards and are not near a wetland. Now, it in fact might have been a wetland 180 years ago, but their house, after all, the farmers in Reading filled wetlands, that's what they did. The town of Reading filled wetlands. We used to say that all you have to do is look for a public school and you found a wetland, which is almost absolutely true. Wood End managed to avoid one. I was amazed. But they
Well, it was built after the regulation. But
So the question then was, how do you want to look at this? The state regulations requires that it be 2 out of the 3. So if there are hydric soils and standing water, if there are wetland plants and hydric soils, if there are wetland plants and standing water, that would define a wetland. As we thought about it, our concern frankly was that there are lots of wet backyards in Reading. We didn't want every one of those to be considered a wetland unless it really was. So 2 out of 3 made the most sense to us.
But if you say that having the plants alone is sufficient, why wouldn't that be sufficient?
One of the challenges is how do you identify it? Okay, there are plenty of well-developed backyards in Reading that were filled 50 years ago, 100 years ago. We had a wonderful situation over on Van Norden Road, 3 houses in a row, one on each side of a gentleman who made the mistake of tearing the house in the middle down, and therefore he was starting all over. And when you start all over, the new rules obtain. So he has 2 neighbors with very big backyards with lots of grass because nobody could prevent them from filling the wetland. He's under the new rules, and therefore he has a very small backyard with lots of wetland plants in it. The challenge really is there are so many areas that were wet once. Wetland plants appear in a lot of places that are not any longer near wetlands. So we go for 2 out of 3, and fundamentally it's what the state uses. We think that's a reasonable compromise. Other questions? Okay.
Actually, I do have one more.
Pardon?
I do have one more.
Sure.
The minor projects.
Yes.
My understanding is that the way Mass General Law works, that bylaws, local bylaws, can only be more restrictive than the state requirements, and they cannot be less restrictive. So when you speak of having a special streamlined process for minor permits, how does that address the fact that it has the bar is at minimum? Because it strikes me as illogical that you could have an easier process that has actually got to be more restrictive than what the state provides.
Because it turns out,
let me take a shot at that. The state attempted to have an exemption or a reduced process for minor projects. It was actually in the regulations at one point. What happened was they could not construct a definition of minor project that could withstand challenge. They tried, but they weren't able to reach consensus on that, so they gave up. So the idea, the concept of something that's so minor that just less than a full application is appropriate is still in the state regulations, but it's not enforced because they couldn't define what it was. We, in Reading, have gone the extra step and provided a definition of what a minor project is. And since we have our definition, the state has gone along in Reading with our definition. So they're comfortable that if it meets the description of a minor project under Reading, then they don't require a full filing.
But if the state was the default for the law, there wouldn't be a necessary requirement for the minor project.
If the state was the default, you could never meet the state's definition of a minor project because they don't have one.
Right.
So every time you did anything within 100 feet of the wetland, you'd have to file a full application.
Right. And the problem with that is, if you're essentially replacing a deck that's been there for 50 years, within 100 feet of a wetland, you would have to file what's called a notice of intent. You would have to meet all of the state regulations, because that's what we adopted, and you would have to undoubtedly pay a substantial fee. Whereas if it is essentially replacing in a developed area such as a lawn, an existing structure on the same footprint, it probably qualifies as a minor project.
And one thing that we're going to do is, it's up there in some of the language, but it's not in the official version. We're going to maintain in Reading, Chuck's going to maintain a list of minor projects. So when we already have a pretty good list, but when new projects come before us, and we say that's a minor project, it goes on that list. So the next person that comes in is going to do the same thing.
So they won't have to file a notice of intent.
Right,
They
exactly.
will actually be able to just execute the minor project and not have to go through the whole state hullabaloo.
I mean, currently, Chuck, what would you say? Every month we have 2 or 3 minor projects at least that come through.
If not more.
Yeah.
Minor projects are pretty big.
That's great.
So I would go back and answer your question this way. If you were to look at the Wetlands Protection Act and eliminate the bylaw, you need to overcome the presumption. And the presumptions are 100 feet within a wetland, 200 feet from a riverfront, and it's up to the commission to determine if you've overcome that. That's how the Wetlands Protection Act. So it turns out to be more who's on the commission if you're just going to go with a Wetlands Protection Act, because it's up to the applicant to prove that he has overcome the presumption that anything that happens within 100 feet of a wetland or 200 feet of a riverfront is going to alter or harm that area.
So if that's a state requirement, and we have a minor permitting.
The minor permit is, Jamie explained that, so
Yeah.
just to have one
Doesn't make
puts a
100-foot
different layer.
setback?
What's that?
So those requirements that you just outlined, Chuck, no longer apply because of the minor permit?
Right. What we end up doing is, because we have a bylaw, okay, we are enabled to do some things that the state doesn't protect. We are also able to make embedded in the regulation certain assumptions which the state presumes differently, okay? Essentially, if we have every right to look at a project that a homeowner thinks is a minor project and say, no, I'm sorry, it's not a minor project. Okay? The difficulty is that if you go with simply the state regulations, not only do you take all the isolated wetlands and not protect them, just like 20 years ago, all of the coastal communities did not find their shellfish beds protected. And rather rapidly, the Commonwealth remembered that, oh my God, we have a shellfishing industry, we better protect the shellfish beds. Is it conceivable that someday the Commonwealth may decide to protect isolated wetlands? It's conceivable. They haven't to date. So by having a local bylaw, by having local regulations, we are able to, 1, enable minor projects, 2, set a setback of 35 feet from a wetland as opposed to the presumptive 100 or 200 feet. In many towns, without a local bylaw,
But that sounds, and I'm sorry, I'm thick. That sounds to me like if the state requires 100 feet.
Well, what the state requires, they identify 100 feet from bordering vegetated wetland, 200 feet from a river.
Right.
And what they say is, I'm paraphrasing, but in essence what they say is, you cannot do anything in that 100 feet that will adversely affect the attributes of the wetland.
Right.
So as Chuck said, it's incumbent upon the applicant to demonstrate what they're doing 99 feet from the wetland will not impact the wetland.
But that's the state law, right?
What we have done in the regulations here is enabled by the bylaws and say that if you're 35 feet back, the presumption is you're not directly affected.
But that's a setback. That's different than 100-foot.
No, it's
No,
not
no,
different.
it's the same
Because
concept.
essentially, if you go to the state regulations, what happens is every applicant is presumed to be damaging the wetlands unless they prove otherwise.
Yeah.
If they're within that 100 feet.
Right.
Or
that's the
200.
bar. That's the base that the state sets.
That's
But
correct.
it is a presumptive destruction, okay? Because we have experience in this town, because we have local bylaws which protect certain isolated wetlands, for example.
Yeah.
We have judged the ability to set certain standards. The setback is one of those standards. The
Yeah,
minor
and sometimes
project
sometimes have no setbacks, sometimes have 25 feet.
sometimes
have
has
35
50 feet.
Sometimes have more, absolutely.
Ma- ma-
So it's a
many-
subjective
many-
choice on behalf of the committee and
many
the town,
towns-
what that number is.
Many towns establish that setback on a case-by-case basis.
Right.
So you might have a 15-foot setback, but your neighbor who came before a different commission, right next door, might have a 50-foot setback.
Yeah. Oh,
We
no,
want to avoid that.
Yeah, no,
standard.
I think it absolutely makes sense to have a standard, right?
Will,
Yeah, I think one of the reasons that Reading came up with the 25-foot no-touch and 35-foot no-build zone or setback was because that's based on 25, 30 years of history of implementing and enforcing the local bylaw as well as the state bylaws. We found that when construction was done closer than that to the wetlands, almost inevitably there was going to be an impact. But again, some towns may have 50 feet, we haven't felt that much of a buffer has been necessary, partly because there's a lot of tight lots in town. So it's a compromise. We're trying to accommodate the nature of our town and the citizens, but also balancing that with protecting the wetlands and the flood protection. So it's, if you just had the state regulations, somebody could argue and get it through a commission. Oh, I can be right up to the wetlands with no buffer at all.
Oh, yeah, I'm not.
And so
Having a specific number is better than having no number. However, if the number is 0 at the state level, then I'm trying to understand.
It's
It's
not
not
zero.
zero. It's a
I'm speaking theoretically. So then that's not really my question. The setback
Yeah.
piece isn't it. I'm still having, and we don't need to bog this down, I'm still having a hard time, I will do the research on my own, how it is that if the law says that the local community cannot be less restrictive, how we can have a beneficial bylaw that makes it easier to do something than the state requires. That's the concept I'm having a hard time grasping. Because you can't be less restrictive than the state. You must be at least as restrictive as the state.
I would say protective rather than restrictive, but yes, that's correct.
and
Protective, you have to do at least what the state says.
Right.
You can't do less than that.
And our minor projects are every bit as protective as what the state is. You just don't have to go through the filing fee, the public hearing, the notices.
Well, they're actually
They're
more protective.
non-substantive.
And I'm not debating whether it's good or bad, they're actually more protective than the state because there's 35 feet where the state doesn't specify that.
no, the state,
No.
there's a
I'm
very
sorry, Mr.
large
Hackett, I know I frustrate you,
No,
but
no, there's a
I'm trying to
very,
understand.
look, there's a very large difference between the presumption of damage. If I say to you, what you did damaged me, and you have to prove that you didn't, you're in a very different position than if I say, I can prove that you damaged me, okay? And what you're misunderstanding is the presumption of damage built into the state law and the power that it enables local conservation commissions to deviate from that. Any local conservation commission, which only has state law, can choose to do what it wants to do as long as it demonstrates to itself a justification. So in a sense, the challenge of being on the Conservation Commission is whether we're stuck with two responsibilities. One of them is enforcing the state regulations, and the second one is enforcing any local bylaw regulations. We act with adjudicatory power. What we've tried to do in the rewrite of the regulations is to make that as specific and plain as possible.
Right. And yet, the premise, I'm not wrong on the premise,
The premise being,
that the process is not less restrictive from the state.
No, what you're presuming is that a presumption of damage on the part of the state is put before a commission to judge on an individual case.
Right, which they have a hard time doing.
What we have historically done is to take the position based on substantial experience in the town, based on the recognition that there are lots of 5,000 square foot lots and smaller in the town of Reading, some of which are built on old filled wetland, and say that we believe that based on our historical precedents, we think that these are the appropriate limits, okay? And
they are protected.
And they are protected, okay? And as long as they're protected, the state has historically sided with the conservation commissions.
Right, that's a slightly different twist on it. Thank you.
Any other questions? Yes?
Yes, Mary Ann Quinn, 42 Benton Circle, also a Realtor. I was wondering if you could address the filing fees. I see here in section D the list of, I believe, the proposed filing fees.
Mhm.
Can you speak to how they compare to what was and how they
Right.
are
What
with
we've
respect to our
done,
neighbors?
if you look at the filing
do you want
fees,
to take that one?
go ahead.
That was an item that was highlighted by the ad hoc committee as something to review. And I undertook a certain part of that. What I did was I looked at the fees, I took our existing fee structure, and looked at the surrounding towns, our immediately abutting towns, and where data was available, I put together a chart that showed what their fees are for comparable applications. So we got a measure, a snapshot of where we stand in comparison to communities like North Reading, Woburn, Wilmington,
We looked at Andover.
Andover,
Wakefield.
Foxford, Wakefield. And we tried to focus our attention on the communities that were most similar to ours. I mean, obviously, we're not similar lot size to all those communities. And we found in general that we were pretty much, we were in the ballpark of what other communities have been charging for fees. So what we did is we went to streamline the fees because a couple of the fees seemed outrageous, kind of egregious, and an unreasonable amount. I think one of our fees was like $11.10 per linear foot, and we just looked at each other and said, "What is this ridiculous 10 cents?"
We had one applicant,
This is, where did this is just.
and we had one applicant show up on the old method, and their fee was something like $60,000.
And right, and so what we did is, we looked at our fee structure to see how it compared to other towns and saw that it pretty much did. We changed a couple of them because they haven't been changed to try and cover some of the costs. These fees go to paying Chuck's salary. And we used to have a full-time administrator, but right now, our current administrator is part-time, but does the work effectively of a full-time position. So You know, as a member, I think it would serve the town better to have more salary available. So a very, very slight increase in those fees, you will see reflected in those changes. And that's an attempt, small attempt, to modestly cover some additional salary. Another side of that is we put a cap on residential permits, fees.
For existing 1- and 2-family owner-occupied houses. One of the things that we recognize is that if you're a developer, you probably have professional staff, you certainly are going to make a fair amount of money in the development, or if you aren't, why are you building houses? So the art form was to say that the owner-occupied house should not be subject to the add-on fees that historically have been there. So we upped the fee slightly for owner-occupied houses and removed all the add-ons. It's neatly scratched out on page 6.
These, just as a, sorry, we'll take that in a minute. Just as a follow-up, these fees have been included in the bylaws, which, correct?
They're the fines, not the filing fee.
Oh, not the filing fees. Oh, okay, I'm sorry.
They're the fines, those bylaws.
Strike that then.
Yes.
Bobby Monticelli, I'm also a realtor, and we're not here to gang up on you guys.
Why not?
Just to get some, well, because.
Everybody else does.
Just to get some clarification. I have a concern, and I've always had this concern, that the fees pay for the administrator's salary, because it just makes me feel like, all right, if we didn't make enough money this year to pay for Chuck, or whoever it was, it doesn't matter who it is, we better get some more fees paid out there. I think I would feel much more comfortable if it came from a fund in the town that wasn't determined on the fees that you get from the community.
Well,
it just makes it sound like, and I know, Peter, you should never have come in right now. You're telling me.
I just had 3 liquor licenses here.
You walked in with Mary Ann talking, that must have put you over, and now I'm talking. But maybe you could address that, Peter.
Well, the fees from that are garnered through these regulations go into a wetland filing fee fund. It's a separate fund, so they don't get distributed to pay my salary or anything else. However, the fees in that fund are nowhere near being close to covering Chuck's salary or the previous administrator's salary. The most we, I think, appropriated in any one year was $6,000. Chuck's salary is a little bit more than that. So the fees help to offset the salaries sometimes. I don't think we have anything in the budget this year. I wouldn't swear to that, but I don't believe we do this year because we had so little fees in that fund. So there was really nothing to
The thing you, look at it this way, we charge a building permit fee. Why? Because the building inspector goes out and does an inspection.
Absolutely.
The average person in town, typical person in town, let me not talk averages, the typical person in town is not near a wetland. If you are near a wetland, there is an added fee because in fact, we have to do an inspection. Even in the case of a minor project, there is an inspection required. So some of that modest additional fee is because you're costing the town services that the typical citizen would not cost. And, you know, that's no different than saying, in my judgment, I mean, obviously we can differ on this, than saying, well, we shouldn't have building permit fees. Well, then you're asking me, as a taxpayer, to subsidize the building department completely. I already pay a fair amount for the building department, but I pay less than I would because we have a fee structure. There are a number of areas in town where we have fees for services. And conservation and the building inspector, getting your wires inspected by the electric wire guy as part of a change in your service. All of those.
You know what, Bill? I agree 100%. We do have to have those fees. Of course, we have to have electric and plumbing and building. In conservation to a certain extent, but I think it just lays a cloud over how much did we need to have those permits? And I was telling you earlier that about 9 years ago, my daughter had to take out a permit and had to get a study on her land for $850 because a neighbor said she was cutting down something that wasn't right, and it was fine. It was determined she was fine, but it cost her a permit and $850 to show that she wasn't doing anything wrong.
And one of the reasons
And
that
that
we
was
have
not fair.
minor project permits, and one of the reasons we've relaxed the standards on maintenance, ordinary maintenance of a property, is to eliminate some, not all of those things.
Yeah.
We cannot prevent somebody's neighbor from coming to the Conservation Commission, as neighbors occasionally do. Be nice to your neighbors, okay? If you're nice to your neighbors, they may not come to the Conservation Commission. If you're not nice to your neighbors, you know, that's one of the recourses. Peter?
Just the other point is, these fees haven't been changed for a while, so it's not like, you know, the Conservation Commission is looking at them every 6 months and jack them up because they didn't create enough revenue the last 6 months or anything like that. I mean, they are stable. They need to be reviewed periodically and should be modified periodically appropriately. This certainly is not a profit center for the town, yeah, I think it's a reasonable approach to fees, and the fees are not unreasonable in terms of the total amount of revenue that they generate.
Can I just ask you where the figure of $50,000 came out? I believe it was last year. I read it. I saw it somewhere that it said $50,000 in fees.
Not to
And
this
again,
conser-
that made me very suspect because that
Not-
was just what Fran's
not to
salary
this-
was.
not to this conservation.
There were periods when, for example, Home Depot and Jordan's was going up. They were huge fees back then.
Right.
Because they were filling wetlands, they were reconstructing wetlands, and it was calculated on a linear foot basis. So back then, and some of our other large development projects years ago, they were very large fees, but nothing recent.
And realistically, those projects, first of all, are large, commercial. Second of all, really required, I happen to be here in the latter stages of Walker's Brook's development. We were out there every week. Okay. Fran was out there 3 times a week, okay, simply because these things have to be observed. And in the case of the Walker's Brook project, that was all essentially mandated by the state because it was in 200 feet of a river.
So the numbers that were shared a year or more ago were that under the state requirements, the fees were $41,000 over a decade in time.
Average.
And the local fees were $206,000.
Right.
So it seems...
That's the total cumulative fee structure.
Correct. So that was my understanding. So the fees, while valid and certainly well explained, seem disproportionate to what the state would require if it's 41. So I guess my question is, what is the expectation with the new fee structure that the typical individual will be looking at?
Part of the problem you have is you looked at a 10-year period that happened to be the decade. That 10-year period was a period in which we had Walker's Brook developed, we had the Market Basket site developed, we had the Stop and Shop site developed, we had the restaurants go in across from Walker's Brook. Each of those large commercial projects paid a large fee. If you look at last year, where we had very small numbers of commercial projects, essentially E-Car was the commercial project, the big commercial project at that. I think last year's fees was $8,000 or $7,000 or
So this year we have
$6,000.
Reading Woods. Is that?
Reading Woods has a very minor
Right.
amount of wetlands in it. Reading Woods, essentially the back quarter of the property, which they will not build on.
Which is up against 90
Which
or
is
95.
up against 128 I-95, has a wetland in it, which they're basically going to be required to keep, not only by us, but by the Commonwealth of Massachusetts, because it was drainage built for 128.
I think what he might be referring to is the state portion of the fee that comes to the town from the notice of intent application,
Right.
which is a tiny amount of
Of
the
the
total
total
fee.
state.
Right.
Because the state gets most of that state fee, and we get a small portion to the town when notice of intent is filed.
Right,
So
that's-
it's really disproportionate.
Yeah, and I'm just trying to understand what is it the expectation that the average business or homeowner can expect coming
One of the
into.
large problems that was identified last summer when we went through this is that particularly for residential properties, the fee structure was too complicated. You had to pay a flat fee to walk in the door, and then the rest of your fee was calculated on how many square feet or how many linear feet of resource was involved. And more often than not, the local resident would miscalculate the fee, and more often than not, we would not understand the calculation, and it was a big mess. So the main thing that we did was for residential properties, eliminate that per foot, per square foot fee, and said it's going to be one flat fee. So now there's just one area of fee, and it's a flat fee, and our estimate is that the normal residential property will pay exactly the same fee, plus or minus 5%, that they paid under the old system. It will just be easier to calculate and easier to understand, so you can look at the regulations and say, this is going to cost me $200. It's not going to cost me $150 plus $11.10 per linear feet and 48 cents per square feet of buffer area, and so on and so forth. That's the main change we made.
And we retained the ability to say to the developer, we have a development site off Forest Street. That developer is subject to a whole different set of regulations that are retained in the fee structure. Other questions? Yes.
So, Carolyn White, on page 6, that's the, it says notice of intent filing fee schedule.
Yes.
So in section I, in the second line, it's changing $1.11 to $100 per square foot, is that right?
Yes.
Wow.
Wait a minute.
That's a buffer zone of a vernal pool. That was the one we needed to edit out. I think we,
Okay,
because the point is, you can't alter.
No.
Fundamentally, within 100 feet of a vernal pool, you can't alter it. Okay.
But we'll need to take a look at that.
Why don't you red pencil it? Because I thought that was the one that we moved it.
I thought we took the whole thing out because the vernal pool has no buffer zone.
Right.
So that actually that whole,
Oh,
I think where you're striking 11 feet.
No, where it is vernal pool habitat, the 11 feet is there. And
$11.
$11 per square foot. And
Yeah.
$100 has to come out because there is no buffer zone.
Right, exactly. Thank you, Carol.
Thank
That
you.
whole second half of that sentence should have been struck. We had, me and some other incompetent word processors do most of this, so please, Paula stepped in at the end and helped us, but we butchered it so badly we couldn't catch it.
Other questions? Okay, we appreciate your written comments. Please leave them at the desk on the way out.
Thank you very much.
You're very welcome.
And there's still some pastries for those of you that ask general questions.
And if you have,
No pastry for me? Fair enough.
we will hopefully,
Just behind the face, Dave.
What did you say?
we will hopefully, just to repeat what Jamie said earlier, we will meet a week from tomorrow, and we will hopefully, pending the feedback, act on these regulations.
And any and everyone's invited to that meeting.
Thank you.
Thank you.
You all feel the earthquake?
What?
No.